Now on to today's speakers. Scott Milner and Jim Walsh are both partners at Morgan Lewis. Scott is a partner in the eData practice and counsels clients on a wide range of discovery topics, from records management and information governance through counseling clients on discovery plans. Jim is a partner in the labor and employment practice and has litigated claims for misappropriation of trade secrets and violation of the Federal Computer Fraud and Abuse Act. He also counsels employers on social media issues. Dan Nucitis is an account executive with FiberLink, and he'll be helping to answer your questions as well. I'll now turn it over to Scott to begin the webinar.
Thank you very much, and good morning and good afternoon for those that are in different time zones. We're very excited about the opportunity to present on one of the, I think, new and exciting topics, bring your own device, that Jim and I are facing in our practices. So what I'd like to first start out with, just to understand who's in the audience right now. I see we're over 200 people now. If we can open the polling question, we're just trying to get a sense of what is your role within your organization. So we'll post this for a couple. Seconds, try to get people to respond, and then we'll get started with some of the rest of the program.
Scott, it looks like as the time is running out, we have most people, close to 60%, answering a technical person figuring out how to control your data, with about 6% answering a lawyer who cannot sleep at night dealing with another source of discoverable information. And let's see, about 13% are managers looking for ways to improve efficiency. And here we go. You should be able to see the poll results now.
Excellent. So I think Jim and I fall into category A. So we're I guess, a little bit in the minority here, but it's good to know a little bit about who's on the audience. And I have one more polling question before we get into some of the substance. And we just like to know, why are people attending this webinar? So we can open this one for a couple of seconds again. That would be great, just to understand why you're here.
Scott, it looks like more than half of our attendees say they have an informal program, but they're looking for additional information on setting up a formal program. And it's about evenly split between those who aren't quite sure what BYOD is or how to set up a program, and people who have a BYOD program and want to benchmark it with others' best practices. And I'll be posting the results in just a few seconds.
Excellent, thank you. And those statistics actually mirror what we're seeing and we're reading in other surveys. So that's good to know. We have the audience that's kind of mirroring what we're seeing. So let me talk a little bit about the agenda, and I apologize for my voice. I'm just getting it back. What we want to do is, for those that don't know what bring your own device is, we're going to just kind of level set what the definition is from different perspectives. Then Jim and I are going to talk a little bit about the legal benefits and risks associated with bring your own device. Some key considerations in rollout implementation, and obviously Dan will jump in with us. For those that aren't aware, what are the privacy concerns? We want to outline those for you. And then from my perspective, what's near and dear to my heart, what is it different for you in your e-discovery obligations with respect to bring your own device now? And at the end of the presentation, we have a number of wrap-up best practices slides, and we'll also work on trying to get to those and or making them available to you after the fact. So here's a nice little slide, and I joke here, and I tell people all the time that if I ever become CEO of a corporation, Etch-a-Sketches will be the only technology that I'll implement in my company, although I may get yelled at. It'll be one of the things that is important, because you look here and they're saying, what is bring your own device? Well, to us and to what we hear from corporations, it's really an alternative strategy that allows employees to use personally selected and purchased client devices to execute enterprise applications and access data. So it's a way for people to use their personal information to access the company data. That's probably the easiest way to put it. And there's several types of programs, including a mandatory BYOD program, meaning you're forcing folks that want to have access to your data to use their own personal device, or a voluntary where you're saying, we're going to supply devices to you, or if you want to access your device, you can do that as well. So why BYOD? And again, looking at the key 5 factors we see is companies are looking at ways to control costs. you know, I know even as a law firm here, we look at ways of how do we save money? What do we want to be in the cell phone business? And so one of the things that we're looking at is how do we control costs? And is there a way that we're able to control the cost by implementing BYOD? Employee morale, improve employee productivity and efficiency. And I kind of somewhat lumped these together. There's some interesting metrics out there. There's a couple studies, both by Dell and Cisco, that talk about that 70% of the companies that believe BYOD can improve their work process and help, I think, gain more traction from their employees. And that 59% that they would actually believe that actually have a competitive disadvantage without some sort of BYOD program. And then if you look at a couple other places, they're saying that for those that don't have BYOD, they're actually seeing a decline in the number of people applying to their positions, and they're actually putting themselves at a competitive disadvantages for gaining talent. And then one of the other, I think, key metrics on the actual productivity, Cisco actually had an analysis that said that you can get an extra 81 minutes of productive time per week with a BYOD program. For me, one of the biggest reasons I started to get rid of my 2 devices is the 2-pocket program. My wife kept yelling at me, why are you carrying 2 different devices at all times everywhere you go? 2 chargers, 2 other things. So it's one of the important things that we were looking at and why BYOD is important. And then as we saw in this one, many people have an informal program, but they're now looking to have a bit more formality around the work that they're allowing their employees to access their company servers through their personal devices. It's really becoming the norm, and it's here to stay. Over 60% of employees use personal devices already. By 2014, 350 million employee-owned devices will be in the enterprise. And then by 2017, half of employers will require BYOD. So again, moving from a voluntary program to a mandatory program, by 2017, more than 50% of employers will require it. So when will organizations switch? And I like the graph here. You can see right now into 2020, companies have no BYOD, some that have the mixed, and then some that will have all. And you can see the trend is moving to all BYOD. So, you know, the question to ask yourself is, where are you in this graph, and where do you expect to be in the next several years? So one more poll question, and we're just for the team here is, what are the main challenges you face with Bring Your Own Device, especially those that have already implemented either into a formal or informal program?
The results are coming in, Scott, and it looks like there's quite an even split, so I'm not going to even try to read it out to you. When the time runs down, I'll post them up so you can see.
Excellent. All right. So I apologize. It's not actually popping up on my screen, but I could tell you from looking at the metrics, it is also an evenly split in the market. The largest percentage that we're seeing is the securely connecting employee devices, dealing with secure, and here, thank you very much. And that actually,
sure.
that's right here, 49% here. And the other 49% is actually establishing a corporate policy on acceptable use. And ironically enough, that was third in one of the national surveys we saw, with number 2 being ensuring mobile device security, which actually is the number 1 from this polling place. So I'm going to turn it over to Jim. Jim's actually going to walk now through some of the risks associated with Bring Your Own Device and give some best practices throughout.
Thanks, Scott. One of the things that employers have found as they rolled out Bring Your Own Device policies is the need to ensure that the personal devices of their employees have appropriate security on them. 1 in 3 individuals does not password protect their smartphone. That's simply unacceptable when there is business information that is stored on that cell phone. Fewer than 1 in 20 smartphones and tablets have any type of third-party security software installed. And companies are just coming to deal with these types of issues. And so one of the benefits of rolling out a complete BYOD program is the opportunity to think about the types of information that the employer will allow the employee to store on the smartphone or the tablet or some other device, and then what type of security best protects that information, and then how to roll out that security. So here at Morgan Lewis, we have several different ways of doing that, including our own mobile device management software that installs profiles that requires us to, for instance, set a personal password for the smartphone, requires that if the smartphone is not attended for 1 minute, that it goes into password protected mode. We are not permitted to use any of the other time periods for non-use. And Dan, you probably have a couple of points that you'd like to make on this.
Yeah, sure, Jim. It's interesting when we, and again, I'm an account executive here with Mass 360. When we first have initial conversations with many organizations in regards to BYOD, it's interesting that most organizations are aware that unmanaged or unaccounted for devices are accessing enterprise information, and they're just really coming to terms of identifying what devices those are. And so mobile device management industry-leading solutions such as Mass 360 offer a few things for peace of mind instantaneously. And the one item that jumps out to me on this slide is that the fact that less than 10% of companies are fully aware of the devices accessing their network. So again, Mass 360 and other industry-leading MDM solutions can give organizations instant visibility into all of the devices that contain or have accessed that enterprise information. So instant visibility will offer a tremendous amount of peace of mind, I assure everybody. And then again, just to reiterate, Jim, what you had mentioned, the most basic level, the first level of defense on these BYOD devices has to be a passcode. There are many ways to ensure passcodes are being enforced. Obviously, MDM can ensure passcodes on the devices themselves. But we just thought we'd like to share some of those realizations and statistics with the crowd.
Thanks, Dan. And following up on that, the FCC released some information from the results of a survey that indicate that an individual loses a cell phone once every 3.5 seconds. So obviously that creates security risk and data privacy risk with respect to any information that is shared from a business to an employee's smartphone or device. But employees increasingly view the ability to use their own device, a tablet, a smartphone, as a right and not a privilege. And interestingly, in a survey, employees will admit they will go around their employer's rules and policies to access corporate information and to use the corporate network. This, in turn, is a reason why IT costs are increasing. The fact that these types of access issues have to be tracked and monitored. And in some situations, and we'll discuss this a little bit more in some of the next slides, wiping a device and how that happens, when it will happen, and most important, obtaining in advance the consent of employees to actually wipe their device if need be. Dan, did you have a comment you want to make?
Yeah, sure. I just, again, would like to comment on the higher IT costs bullet point here on the slide. I think we've already covered the statistics where a BYOD program as a whole can save organizations thousands of dollars in regards to cost of wireless plans and devices themselves. Naturally, to effectively implement a BYOD solution, it's highly recommended and not quite mandatory yet, but it's close that you implement an MDM solution, especially an industry-leading MDM solution such as Mass 360. Naturally, there's a cost associated with MDM. However, in talking to our customers and even our potential customers, we see that it's not just the actual savings from offloading those corporate plans. That's appreciated. It's also it's a sigh of relief from IT. MDM offers a tremendous amount of productivity for IT administration to centrally manage these devices, to secure the information quickly and effectively. So from a cost perspective, naturally there is a cost of an MDM cost for implementing BYOD, but far outweighing that minimal cost is the savings from the enablement of BYOD, but also from the productivity increase for IT administration.
Thanks, Dan. Further risks include state law security obligations for protecting personal information like Social Security numbers, driver's license numbers, and most individually owned devices do not have as robust malware and virus protection as devices provided by employers. One of the things that we're seeing more in the press and in cases and when we're giving advice to clients is the use of the cloud and problems that arise when employees, many of them, automatically sync their devices to Dropbox or a similar service or product so that when they are at home, they sync, information is pulled over that may be business information, it may be personal information, and it's stored out in the cloud. And when that employee leaves the company, employers are then learning, there is all this information that's been stored in the cloud, not under the employer's control, and possibly without the right of the employer to gain access to that information. These are all things that should be taken into consideration when designing a BYOD program.
And Jim, just to add a bit of color here, it's interesting. I'm actually looking at the questions that are popping up, and there's a question asking, how do we determine when you need an MDM over the 40 policies available in Exchange Active Sync? And really, to talk to or to answer that question, I'd like to mention a few things that again, Mass 360 and other leading MDM solutions can really help you address non-employee access to mobile devices, for example, as well as the cloud challenges. And these are issues that ActiveSync can't natively help you address. So just to elaborate, a part of our solution here at Mass 360 is the option to create dual personas on devices, or create a container, for lack of a better term. And that's where we're securing just that enterprise information. And so to address non-employee access, rather than enforcing a passcode on the device itself, we can just put a passcode around that dual persona or that container on the device itself. So we're protecting that enterprise information, the corporate data that needs to be protected, while leaving the device itself untouched. So to address non-employee access. Again, ActiveSync can't do that natively. Also cloud. You think of all of the personal applications that users download on their devices, the Dropbox, the Box.com. It's very easy and very simple for an employee to unintentionally offload sensitive data into a Dropbox account. And again, that's where mobile device management can help address a lot of these security challenges for IT organizations. We have multiple methods. We could also restrict our containers' ability to share that data with these third-party applications, or we can actually whitelist and blacklist specific applications which restrict the permission to use these applications on devices themselves. So a number of different approaches to managing these risks here on this slide, all of which MDM can afford organizations, while the native ActiveSync settings cannot.
Okay, thanks, Dan. Two major points with respect to the next slide on privacy considerations. First, be sure to obtain in advance a very clear and express consent from employees who will be enrolled in a BYOD program that they are waiving and understand and acknowledge that the employer may access their personal device, may need to wipe business information from the device, which potentially may cause wiping of some personal information as well. Number two, keep that consent in a safe place. If an issue comes up that needs to be addressed with respect to an employer's actions on an employee-owned device, you will want to be able to prove that you had the right to access the device and to make the changes that may be in question. One of the reasons that that's so important is various state laws provide for rights of privacy, either in common law through cases, or as in California, its Constitution specifies a right of privacy for employees. There are federal laws like the Computer Fraud and Abuse Act, through which there can be liability for a person who accesses somebody else's device without proper authorization. There are significant penalties that can be imposed for such unauthorized access. Another federal law that's often referenced is the Stored Communications Act, which prohibits unauthorized access to email and other files that are stored remotely. And for instance, if you have an employee who has left your employ and on their laptop they were accessing their personal email accounts, and perhaps they've saved their password and username on the laptop, you should in no way access that information, as it may trigger the Stored Communications Act and liability under that act.
And Jim, if you don't mind, if I could just add a bit here. When we work with organizations in regards to enabling BYOD, one of the first things we encourage everybody to do is to really, again, come up with that BYOD policy first. It's interesting, Mass 360 publishes a number of white papers. One of our most popular white papers that's been downloaded thousands of times is one we call the 10 Commandments of BYOD. And the first commandment on that paper is, again, to have that written policy that clearly defines the rules and the expectations for users bringing their personal devices into the organization. With our solution here at Mass 360, we actually can give organizations the option to, once they've created that BYOD policy, to then upload that policy into our solution, so that when a user does enroll their device to gain access to email and Wi-Fi and applications and documents, a part of that enrollment process is the requirement that they formally accept that written BYOD policy. So we can help organizations get an additional layer of confirmation that employees are agreeing to the rules and restrictions and expectations in place for BYOD. Sorry, Jim, I just wanted to throw that in.
No, that's an important point, Dan, and certainly having obtaining more than one consent is preferable, so long as the language in the consent is consistent. Sorry, I flipped past this. So as an example, the Brooks v. AM Resorts case is a fairly recent case that implicated both the Computer Fraud and Abuse Act and the Stored Communications Act. And in a nutshell, after an employee left employment, the employer used the employee's individual personal email account to access some information, and the employee brought a claim. Now, part of the claim was dismissed by the court, the Computer Fraud and Abuse Act claim, because the employee could not meet the statutory elements of the claim, including he could not demonstrate $5,000 worth of loss. But certain claims were allowed to go forward, including a Stored Communications Act claim, because the court found that the employer had accessed emails that had not been opened by the employee and therefore fell within the protections of the Stored Communications Act. Technical considerations, and these are obviously considerations from a technical standpoint, but they have an impact on the legal position of the company, particularly what happens when a lawsuit is filed and the federal rules and state rules of civil procedure are implicated, which mandate that employers preserve all relevant evidence, which includes evidence that may be on an employee's personal device. Certain security settings obviously have to be considered, including password protection, encryption, auto-sync, restrictions on where on the device the employees can store data, if at all. Who are different users in the company treated differently? So there are different advanced connectivity tools that I'm sure Dan can talk about that allow certain individuals in the company to access more data or different types of data than others. Tracking and the ability to remote wipe the devices is important. When sitting down with a witness or a client to stake out what information needs to be preserved, all of these questions have to be answered. Who has access? What type of access do they have? And the individuals themselves may not even know the full extent of the access that they have or the data that's on their devices. You may need to work, for those of us who are attorneys online, with the IT departments of clients to determine exactly what the extent of data storage is, and then, of course, whether that data is stored, the business data is stored with personal data, raises all of the issues that we've discussed previously concerning employees' right to privacy and authorized access to such data. Dan, did you want to make any comments before I throw it back over to Scott?
Just a quick comment from a technical standpoint. Obviously, MDM or mobile device management is able to create different policies and assign those policies to different users or groups of users. So the technical ability is there. Whether or not you take advantage of that is certainly an option for the organizations. There's a lot of beneficial use cases that Mass 360 can share with organizations as to where this makes sense from an access standpoint. The tracking and the remote wipe, just a quick mention that our solution has the ability to restrict IT or an organization's access to what we consider personal information when it makes sense. So the two pieces of data that we can restrict access to for IT is physical location being one. So if that's ever a challenge or a concern from a BYOD standpoint, we can essentially remove our ability to see that physical location. And the other one would be application inventory. So again, just quickly wanted to mention we do have privacy controls that are available in our MDM solution as well.
Thanks, Dan. I'm going to turn it back over to Scott.
So for those litigators out there or any of the e-discovery folks on the phone, this is probably not an unfamiliar chart. This is called the Electronic Discovery Reference Model, or EDRM. This really serves as a life cycle of a document for purposes of really information management, meaning pre-litigation record retention through presentation potentially at trial. BYOD has a primary or larger role within the first kind of left side of the quadrant, and information management is one of them. It's important to address BYOD in your information management or information governance policies, because if you're allowing companies to store business capital R records on these devices, and that device can be mobile device, it could be personal laptop, it could be a tablet, it could be home computers. So you have to remember that if people can store data outside the firewall and the network, you have to put something in place, and information management is one of the first places. So employees' personal data on personal devices. So back in the day, there was a clear separation in the courts about personal devices are personal, business communications are business, and that with the kind of growing trend of BYOD, courts are being more willing to allow companies to seek information from personal devices. And so the question we always have to ask ourselves is, consider whether the data is unique or relevant on those devices. So if you have an MDM solution, or you have some policy and restrictions against information where they can store it, you may not even have to worry. It may not change your current discovery plan, but most companies don't have that level of sophistication or detail on their program yet. So still questions that you have to ask. Getting into that first phase, data identification, we talked a little bit about, Jim talked about importance of maintaining, the list of access and devices that have access to your information. And when you're talking to employees, making sure you're asking whether information on those devices may be subject to the legal retention and legal preservation obligations. People always ask me, so what are the cases saying? And I think we saw some questions about, I think everybody recognizes that an iPhone and a tablet is something that's important for BYOD, but what about other things? So here's a couple of lines of cases, and these are all throughout the country, including the Southern District of New York, the District of South Carolina, the Southern District of California, and the Eastern District of Maryland, or Michigan, where they talk about what is the employer's responsibility for personal devices. So in the first one, you see an employer was responsible for employees' deletion of emails, text messages, and Skype messages from their personal device. In the other case, in the case out of the District of South Carolina, the court actually required inspection of home computers when employees use home computers for work and were not issued a company laptop. So for any of the technical people that are not giving laptops and either giving iPads or allowing people to connect with their personal computer, the courts are becoming clear that that is still within your possession, custody, or control, and therefore a source of information for discovery. In a case in the Southern District of California, the court found that spoliation had occurred and the employer was responsible when an employee deleted material from his home computer when the company knew and was aware of information that being stored outside of their systems. And then the last case, again, was employer responsible for employees' deletion of relevant emails from their personal email account. So again, somebody had a Gmail, AOL, Yahoo account, and it was subject to discovery. They didn't put their appropriate preservation measures in place. There was some issue for the employer and what their responsibility in preserving those data. So what are some of the steps for you litigators and kind of your considerations for dealing with BYOD? Make sure your legal hold or your litigation hold memos take into account the BYOD program you have in place. So if you have, you're allowing people to store data on their personal computer, make sure you list that as a source they have to be looking at for preserving data. For the type of cases, think about what the method of preservation is. Do you allow the company or the employee to preserve everything in place, or for certain data sources, do you actually go ahead and collect the data so you avoid information being inadvertently destroyed because it's on their personal computer? So I'm a custodian in litigation A. I know it's a bet the company case, and I may make the decision, instead of telling the company, that person to preserve it, I may say, I'm just going to go collect that personal computer and work with either my MDM software or work with the employee to identify any company records on that computer. And then what are the risks of spoliation? And again, spoliation, if I look at it, spoliation really is about 50% of the cases where companies are getting sanctioned for discovery violations. 50% of them are because of spoliation. So some of the considerations are thinking about how certain types of data is destroyed automatically. I know my call log only lasts for so long on my phone, and that could be relevant. My text messages may leave. My pictures may overwrite if I run out of data. So things like that may be considered spoliation if they're subject to your preservation obligations. And another big one, that second bullet point, employees subject to a legal hold, if they leave, if they lose their phone, if they destroy their phone, if they upgrade their device, depending on the steps they're taking and what you as a company have instituted with the BYOD program, there could be some inadvertent spoliation going on. I mean, I read a number, and I think Jim alluded to this, the 3.5 seconds. I read a number just in New York City alone. I think it was 60,000 mobile phones get lost in cabs every year, I believe. It's just astronomical. And if you have data that's relevant to litigation there, that could be considered spoliation. After you preserve the data, then you actually have to start collecting the information. Well, when you're implementing these, you have to think about what additional software in-house do I have to collect the information. What about, people have remote workforces all the time. How do I handle that? How do I handle data that's outside the U.S.? For those litigators that are aware, I mean, most countries outside the U.S. have sort of data privacy issues where, unlike the U.S., employees outside of the U.S. have a bit more expectation of privacy on their data. So how do you deal with issues in collecting data that's outside the U.S.? If you have a compliance review, you have somebody that you're worried about doing something wrong and it's regulated, how do you collect their data without them knowing? And how do you make sure you're preserving metadata? And for those non-litigators, metadata is information about the document or information about the record. So if you're doing certain things and you have your system set in place, how are you confirming that you're collecting the information? How do you get access to the devices? These are some of the challenges we see. You have a disgruntled employee that leaves. They have company information there. If you don't have a program set up correctly and you need to preserve that information for discovery, they leave the company or they wipe it. How do you have any control over it? These are challenges that we're seeing companies have all the time. And then we've talked a little bit already about the segregation of personal versus company data. And without an appropriate program and really the right technology solution, there's the potential that when you're collecting information, especially from people outside the U.S., you may be collecting protected information that is problematic versus just your company documents. So now turning it back to Jim, talk a little bit more about, again, the employment considerations from the legal perspective. So Jim, let me turn it back over to you.
Thanks, Scott. I appreciate it. So when a BYOD program is rolled out and employees are using their smartphones or other devices, which may include laptops, for work and personal reasons, you know, the lines of distinction between what is work and what's personal can become blurred. And this, you know, for years there have been issues outside of the workplace, so outside of the office, in which employees get into disputes with other employees. When the employees are now using perhaps the company's email system on their personal email or their personal phones or laptops, it doesn't change the fact that there's an impact in the workplace. And depending on the situation, an employer may have an obligation to investigate an employee's use of their personal device along the same lines as they would if an employee were found to be harassing another employee using an employer's company-provided computer. You know, another area of concern is the use of social media sites through personal devices. Certainly if an employee is posting on social media sites about items that relate to the company's line of business, the company should be sure to direct employees through a distributed policy that they should not attribute any of their own opinions to the company. But those are things that are typically addressed in a social media or internet usage policy. And they overlap, though, with bring your own device issues. You know, so as an example of the blurring of the lines, in a case called Espinoza v. County of Orange, a plaintiff was born with a deformed right hand, and his coworkers created blogs outside of work on which, though, they commented about work-related items. Some individuals identified themselves by name, others posted anonymously. And certain of the posts became very vicious and inappropriate with respect to the plaintiff's disability. The employer at trial attempted to defend its actions by saying, hey, this is all work that occurred outside of the workplace. And the court rejected that argument on two grounds. One, it found that some of the posts were made while individuals were actually at work at their own computers. But two, it found that even outside of work, there were fact issues with respect to how much of the content was posted outside of the workplace. I think an important question that this case raises is if an employer permits employees to use the employer systems on their own device, and employees then use that device to harass an employee, is it relevant that it happens outside the office as opposed to inside the office? And I can tell you that I believe many plaintiffs' attorneys would make an argument that the employer has essentially permitted employees to have access to a tool through which the harassment occurred, even though that tool is a personally owned device. The employer then has taken on a responsibility to investigate and remediate any alleged harassment. In terms of discrimination, disparate treatment refers to cases in which an employer intentionally discriminates against an individual. So with respect to hiring decisions or promotion decisions, if an employer accesses information on an employee's personally owned device, it is liable to contain information about the individual, such as their marital status, whether they have kids, whether they have a disability, and these are characteristics that an employer cannot take into account when making employment decisions. So there's a risk that the individuals who access personally owned devices will have information that they cannot then act upon. And it's important in the BYOD program and its policies to instruct employees who have such access and to train them that they need to keep such information personal and private, and they need to divorce themselves from making employment decisions that are based on such information. BYOD programs also raise wage and hour issues. Some individuals have been posting questions about how does a BYOD program interact with independent contractors. That's a very important question, because if you roll out your BYOD program to employees as well as to independent contractors, it's a consideration for a court if an independent contractor sues and claims that he or she is actually an employee. The access to the employer's data can then become an issue, and it can be an indicator that a person is closer to being an employee than to being an independent contractor. These are all important considerations to take into account, because it may be, again, based on the circumstances of your BYOD program, based on what the contractor actually needs, based on what other access might be available, an employer may decide not to include independent contractors at all in the BYOD program. If they are able to limit the type of access and demonstrate that this is essential information through which the independent contractor cannot otherwise perform their duties, but there are enough other factors weighing in favor of a finding of an independent contractor status, that then it may be that an employer will decide to roll out the BYOD program in some situations to contractors. But it all has to be considered very specifically with regard to the facts at hand. And it's unfortunately not a topic that can be resolved or in a webinar or through a Q&A session on a webinar. But with respect to employees, there are a whole host of issues, from if your non-exempt employees have access to company data on their own devices, have they been instructed not to use those devices off hours? And have they been instructed, if a manager has instructed them to work off hours, that they report and they log all of the hours that they work so that they can be appropriately paid? You also have to consider whether employees will claim that they are missing meal breaks or rest breaks. And you also may need to consider whether your telecommuter policy overlaps or takes into consideration these same types of issues. There are certain states that require that employers reimburse employees for out-of-pocket expenses that are incurred as a consequence of performing their job duties. California is one. And so if you are rolling out a BYOD program in California, you need to consider whether or not you are required to reimburse employees for certain costs that they incur for participating in the BYOD program. There may also be tax consequences for those reimbursements that should be considered. Dan, did you have any points that you wanted to make on these slides?
I'm sorry, Jim. I was actually responding to some questions here.
No problem. I'm going to turn it back over to Scott. I just was checking Dan to see if you wanted to add anything into the discussion.
I certainly appreciate it.
Well,
Scott?
Thank you. And I'm gonna skip the best practice, try to answer some questions, and then we have some time at the end. We can, as I say, one more time with feeling. It's a bit of a summary, but it's a couple good questions on the board. I'm just getting to those now. The first question I thought was interesting was, can spoliation occur if users are allowed access from a personal device via a VPN connection? I mean, spoliation can occur at any time. People can unilaterally delete things. When I talk about spoliation from a litigation perspective, I'm talking about protecting and thinking about ways to protect against whether it be routine spoliation, meaning or routine deletion, not spoliation, obviously, routine deletion of information that is happening. So to the extent of a document is happening right now, and all the data is still stored on your company server, and the connection is only through VPN, then you're really not going to run into the information. The information that's problematic, or spoliation that's problematic, is if the only unique relevant data source is on a personal device that you're not putting into your preservation plan. So hopefully that answers the question on whether use of VPN can help, I guess, eliminate or reduce the likelihood of spoliation. And again, just to reiterate, the importance is making sure that the data that is on the personal device is either not relevant to the obligation to be preserved, or it's duplicative to what is available on the company network. And therefore, if somebody were to delete it, or you had to wipe it because somebody lost their phone, or they broke their hard drive crashed at their personal computer, that you're protected from that perspective. Another question, I think, similar lines, many organizations utilize Citrix to allow smart devices to access enterprise data, including email, when not allowing any data to be saved on the smart devices. Is this a smart strategy? And what are the deficiencies in utilizing such a strategy? From a benchmarking perspective, and obviously Dan can weigh in if he wants to from another perspective, from what I'm hearing companies doing, a lot of companies are using this as a short-term solution, as a way to, again, restrict what people are saving on their devices, because in reality, it's not just a litigation reason that you're doing it. You're doing it because you may be regulated. As Jim mentioned, some states actually have real penalties if you have PII or HIPAA-related information that's not encrypted, it's on a device. It's your company assets. One of the biggest upticks in litigation that I've been dealing with is employee A leaves the company. Employee A had their personal devices syncing to Dropbox. Their personal device had customer lists, some trade secret information. They sync it up to Dropbox. They give that personal device to the IT. The IT scrubs the device, says, all right, you're good to go. They go to their home computer. They turn their home computer on. They sync with their Dropbox account. Dropbox now pulls all of that company's data to their personal computer. Whether it was malicious or not, still company information that you did not intend to leave the company. So we've been representing a number of companies for people that have left the company with personal devices, moving up to Dropbox or other cloud storage, and then moving it to personal devices later. So in some ways, putting more control around it with either an MDM or with using things like VPN and Citrix, restricting where data can leave the company, will help avoid some of those problems.
And I think just to add to that question, I think the final part was what are the deficiencies in utilizing such a strategy. It's important to keep in mind that BYOD is designed to increase productivity, and one thing that I've learned here since I've joined the Mass 360 team is that users really want a simple way to access enterprise information. And they want it to be simple and fast. So I guess what I'm trying to say is the only potential deficiency would be that it's more steps for the user to go through, or hoops to jump through for them to be able to access that enterprise information. What MDM allows, what Mass 360 allows, is the assurance that this data is going to be protected. You containerize it to ensure that it's not being shared with outside applications, but at the same time, the MDM is a one-step setup process. You know, it doesn't require additional hoops to jump through a lot of times. So just from a, I guess, more of a technical perspective, you know, that could be considered a deficiency, but I guess that's ultimately up for organizations and users to decide. So just wanted to add my 2 cents in there as well.
Thanks, Dan. And I see another question, you know, and I apologize, I probably put too much of my legal hat on. There was a question, what is the actual definition of spoliation? And if you look at, you know, the Black Law Dictionary and some, it's basically the deletion of information that you're required to preserve from a litigation perspective. So you know, I tried to just Google if I can come up with it, but it's you know, an erasure or alteration of information that is required to be preserved and produced that's within your possession, custody, or control. So the whole concept of spoliation is when you get a lawsuit and you have notice of litigation, you're obligated as a company or as an individual to preserve or retain the information that is potentially responsive to any discovery demand, and a lot of that is email, a lot of that is text messages, a lot of that is social media information now, and so you're obligated to retain that. And if somebody actively deletes that information before they produce that information, that's considered spoliation, or could be considered spoliation, I should say. Carly, have we answered, all right, there's some more questions coming in. So I'm just trying to read through to make sure we've captured everything.
It looks like a question just came in from Janice. Not being a legal person, what are the implications of BYOD if there aren't employees but contractors instead? More issues to consider or less?
That's a great question, Janice. You're not the first person to ask a question about independent contractor status. And the answer is you may wind up with employees depending on the nature of the work and the other circumstances with respect to the type of work and the type of assignment that the independent contractors are performing. You know, if there's a situation in which you've got an independent contractor who's on a short-term assignment, say of 3 months, and they are going to handle an issue that where you are not going to give them a lot of direction, you will not control how they perform the work, which means that generally they would be found to be an independent contractor, then giving them some form of access to a BYOD to enable them to get their work done will probably not lead to a conclusion that they are a common law employee. But if you change those facts around a little bit, the risks of a finding of an employee status as opposed to an independent contractor status, which has wage and hour implications and tax implications, you know, the facts will dictate sort of how much additional risk there is. So if you change that around, it's now an independent contractor who's not on a 3-month assignment, but they've been working day in and day out at your establishment for a period of years. That you are, you know, have a great degree or some degree of control over the manner and method in which they perform their work, and now you're also going to include them in a BYOD program. You know, that starts to look a lot like an employee and not like an independent contractor. And so there, including them in a BYOD program would simply add to the factors that a court may weigh in determining independent contractor versus employee status. And in that case, it would weigh more in favor of employee status than contractor status.
I think we have another question here from Greg. Is there an overall strategy or workflow/template to help establish a solid strategy? I believe what Greg is asking is to help establish a solid BYOD policy. I hope I'm understanding that question correctly. And what I'll say is, Scott, if you could actually forward the slide to our contact information page. I just want to make sure that everybody has that info. We here at Mass 360, you know, we deal with BYOD all day, every day. So we do have resources here that I'd be glad to share with anybody interested that will help you, or at least get you started in regards to creating a robust BYOD policy. We have samples and we have templates, so if anybody has an interest, please shoot me a quick email. I'd be glad to share that information with anybody on the call.
And Dan, from the legal perspective, I think Jim and I spent, a part of our practice, especially over the last 6 months to a year, working with companies on building a BYOD program, starting with policy, and then working with their respective IT teams to implement either an NDM or just other technical solutions to assist with that. So we also are happy to help in any way in looking at what some of the legal issues are. What are some of the must-haves in your policy? I mean, we've seen a whole host of policies that have some really good language and some really poor language, including I've seen a couple policies where I think the company put too much of the presumption on themselves that they have to take all these steps versus adding almost an unrebuttable and unrefusable consent by just participating in the program, that from a litigation perspective they've got to comply with things, and not really giving the rest of their corporate department like HR the appropriate information or guidance and questions to add to their exit interview. And just to go back to one slide on that issue, I think this one here is kind of important, is if you are rolling out a program, don't forget how it interplays with other policies. I've seen too many times where people forget to have the policies talk to each other and make sure that they're consistent, your code of business conduct and all that. And the other one I'm big on is the exit interview policy, especially because unless you're doing certain things that changes what you have, if you don't tell people what they're doing when they leave the company, you may be letting people leave with company assets. Whether they're subject to preservation or not, it's still company assets.
Scott, I think we have pretty much come to the top of the hour, so thank you so much to both of you for taking so much time to answer all of these questions, and thank all of you for joining us. You will be receiving an email tomorrow that will provide you with access to the recording and slides for today's event so that you can review any material you missed or share it with others. You have our contact information on the screen before you, so if you have follow-up questions about Mass 360, you can contact Dan, or legal questions for Scott and for Jim. And on behalf of our presenters, Scott Milner, Jim Walsh, and Dan Macedas, as well as all the folks at FiberLink, we hope you enjoyed today's presentation and have a productive and secure rest of your day.